Hey there, everyone. Josh Crowfoot here, Crowfoot Law Firm in Chattanooga, Tennessee. I'm a commercial real estate lawyer, and we're here on day 32 of Commercial Real Estate 101. We are discussing commercial leases, and today we're going to be talking about quiet enjoyment and what that means. Quiet enjoyment is a legal phrase, a legal term, and what it means is the landlord, so long as the tenant is not in default under the lease, is going to covenant to the tenant that the landlord has good title to the property. So a lot of folks think quiet enjoyment means that the landlord is promising to the tenant that the premises is not going to be noisy or something like that. And there are obligations that the landlord can agree to that would cover that. But quiet enjoyment actually has a legal definition, which is the landlord is making a promise to the tenant that no other interest or landlord owns the property, that the landlord has a right to lease that property to the tenant. Sometimes a tenant will ask for an additional representation from the landlord. They'll ask the landlord, promise that it will take care of the premises and keep it in a first-class condition. That's an important thing for the tenant to ask for. It protects the tenant in case you have a bad landlord and the landlord's letting the space deteriorate, not maintaining the property. You don't want to be a tenant in a situation where the premises that you're leasing and paying good money for is not being maintained and it's starting to become uninhabitable. You need some provisions in there that can protect you. That being said, when it comes to repairs and maintenance, those items are usually heavily negotiated, and what's customary between the parties is that the landlord will agree to maintain and repair the foundation, structural items, buttresses, supports, the like, as well as the roof. Sometimes the roof is negotiated, but heavily negotiated, but typically a landlord will agree to maintain the roof. And then everything else is the responsibility of the tenant. So while it's good for the tenant to get that representation that things will be maintained in a first-class condition, the division of responsibility over who maintains and repairs a space is always heavily negotiated. Hope you learned something new.